Welcome back to Case Brief. Today, we're exploring a landmark case that shaped modern contract law involving persons mentally disordered and drunkards, Imperial Lone County v. Stone, 1892. This case dealt with persons mentally disordered and drunkards, the right to rescind or void a contract. If you're curious about how the courts tackle legal issues in persons mentally disordered and drunkards claims, stick around. Introduction, definition. In contract law, a person's capacity to enter into a legally binding agreement is a fundamental requirement. Individuals who are mentally disordered or intoxicated may lack the capacity to form a valid contract. Under English law, a contract entered into by a person who is either intoxicated, to the extent they do not understand the contract's nature, may be voidable if the other party knew or ought to have known of the incapacity. A prominent UK case that illustrates mental incapacity in contract law is Imperial Lone County v. Stone, 1892, 1 QB 599. This case confirmed that a contract is voidable if the individual lacked capacity and the other party was aware of their condition. Case background. The case of Imperial Lone County v. Stone, 1892, 1 QB 599 involves a claim by a loan company seeking repayment from an individual who argued that he lacked mental capacity at the time of signing the contract. The court had to determine whether his incapacity rendered the contract void or merely voidable. Facts of the case. Mr. Stone, the defendant, had entered into a loan agreement with Imperial Loan Company. He later claimed that he suffered from mental incapacity and was unable to understand the nature of the contract. The loan company sought to enforce the agreement despite his claim of incapacity. The key issue was whether his mental condition invalidated the contract. Nature of the case. This was a contractual dispute concerning the legal capacity of an individual with a mental disorder. The court had to determine 1. Whether a mentally incapacitated person can enter into a valid contract. 2. If the contract was void or voidable due to the defendant's mental condition. What are the legal issues? The primary legal questions in this case were: does mental incapacity automatically void a contract? 2. Is a contract voidable if the other party was unaware of the mental disorder? The case clarified that a contract made by a mentally incapacitated person is not automatically void. It is merely voidable if the other party was aware of the incapacity at the time of agreement. Judgment. The court ruled in favor of Imperial Loan Co., stating, a contract entered into by a person of unsound mind is not automatically void but is voidable. The contract remains binding unless the mentally disordered party can prove that 1. They lacked understanding of the contract's nature. 2. The other party knew or ought to have known about their incapacity. Presiding Judge Lord Esher Mr. stated, when a person enters into a contract and afterwards alleges that he was so insane at the time as not to know what he was doing, and the other party knew it, then the contract is voidable at his option. This means that a mentally disordered person can choose to void the contract if they can prove that the other party took advantage of their incapacity. Similar cases: Hart v. O'Connor, 1985. AC 1000. A contract is valid if the party alleging incapacity was not exploited and the other party acted in good faith. Gore v. Gibson 184313M and W 623. A contract made by a drunk person is voidable if they were so intoxicated that they could not understand the contract and the other party knew of their condition. Matthews v. Baxter, 1873. LR8EXCH 132. A contract entered into while drunk can be ratified once the individual regains sobriety. Implications of the case and precedent set. This case set key legal principles on mental incapacity and contracts. Contracts with mentally incapacitated persons are not void but voidable if the other party knew of the incapacity. If the other party was unaware, the contract remains binding. This principle also applies to contracts entered into by drunk persons. They must prove they lacked understanding and that the other party knew of their intoxication. In modern contract law, this principle is relevant in consumer protection, financial agreements, and elderly care contracts where mental capacity issues may arise. Case summary: Imperial Loan County v. Stone, 1892, established that contracts made by mentally incapacitated individuals are not automatically void but are voidable if the other party knew of their incapacity. The ruling clarified that the burden of proof lies on the mentally incapacitated party to show that they lacked understanding and that the other party was aware. This principle extends to drunkenness, as seen in Gore v. Gibson, 1843, and Matthews v. Baxter, 1873. The case remains a foundational precedent in contract law regarding mental incapacity and intoxication. Thanks for watching.